Yeah, thank you so much. Good afternoon again, ladies and gentlemen, dear colleagues, dear friends. The presentation I am giving here is a little bit from a field where I have basic knowledge. As a patent attorney, at least in my country, should basically have it always. But it has essentially been prepared by Dr. Ute Kilger, a partner of mine, specializing in biotech pharma, working exclusively in that field. And unfortunately, she could not come here because she is presently at the West Coast in the United States and near San Francisco, in San Francisco, and has asked me to give this presentation here. I will try my best, and I would like to focus particularly on a rather strange situation which historically has developed in Europe, specifically in Germany, since 1998 with regard to something those of you who know at least a little bit about the problems with patenting biotechnological inventions are familiar with. It is a so-called biodirective of the European Union from 1998. This biodirective tried to define the patent eligibility and patentability in the sense of patentable in relation to prior art of biotechnical inventions, and particularly a specific kind thereof, namely parts of the human body with a specific aspect, if I say parts, on gene sequences, and particularly those gene sequences which are isolated from the human body and possibly might be patentable. So people might say something which is in nature and was known to the public all the time cannot be patented anymore. But this does not apply to this type of inventions I'm talking about. Rather, the biodirective in its Article 5 specifically says in Article 2 that such elements isolated from the human body can be patented. 1998. This biodirective was then taken into the set of law and regulation of the European Patent Office in Munich very quickly, identically, part of European EPC law, European Patent Convention law since then. The interesting part in this, I think, Article 5 is the last sentence, namely that the industrial application of a sequence or a partial sequence of a gene must be disclosed in the patent application. The addition of this rule into the biodirective was the result of a long-lasting, nearly a decade-long fight between various countries, I would say, in the European Union who had a different opinion with regard to the patentability of, in particular, gene sequences. There was on one side Germany, which did not wish patentability, if I understand, and I have followed this discussion rather intensively, that just such gene sequences, even if isolated from the human body, should be patentable. And there was on the other side, particularly a country, United Kingdom, but also other countries supporting that position, who wanted an unrestricted patentability of isolated parts, including gene sequences, of course, of the human body. Since they could not agree on a clearer formulation, the compromise as contained here was chosen, reading in Article 3 that the industrial application, the function, the way how to use it, the purpose, has to be disclosed in the patent application immediately after publication of the biodirective. That means before even the national parliaments in Europe implemented this directive into national law. And directives, just for those of you who are not daily concerned with legislative processes in the European Union, must be implemented nationally. Directives are not immediately applicable laws like a regulation, like now the proposed regulations concerning a European unified patent system we have talked about already earlier in this conference, but they are directive instructions to the member countries of the European Union to change and modify their laws so that the provisions of such a directive are fulfilled. Germany needed about 7 years to ratify and to implement this regulation, or better to say, this directive into German law. And they did this with a specific understanding of what Article 5 means, namely by interpreting the paragraph 3 in such a manner that they understood it, they wanted to understand it like this, as meaning the German position, namely, you cannot patent with the effect that you can exclude others from the use thereof, an isolated part, an isolated gene sequence from the human body. Therefore, Germany implemented, different from the European Patent Organization, or EPO. EPO means two things, the abbreviated form. One is the European Patent Organization, the, I would say, materialized European Patent Convention, and the other, EPO, is the European Patent Office at Munich, physical organization. They interpreted this as meaning that you have to take the disclosed purpose, functionality of the gene sequence into the patent claim, saying by that the at least literal scope of protection of such a patent is restricted to the gene for a certain purpose, used in a specific function. There were long considerations by the other member countries of the European Union, which we could follow in the political discussion, as to whether Germany, by doing so, really had implemented the Biodirective, or whether what they had ratified was something else, which was never told to them to do by the Biodirective. But be it as it is. Now, lean back and look at the situation as we have it in Europe now. There is a country, Germany, which understands the Biodirective and has a patent law according to which, in the patent claim, the isolated gene must be defined as being used for a certain purpose. That means, in terms of claim construction, very easily, and standing case law of all courts you can think of in Germany have defined that this means that if somebody uses this isolated element for some other purpose, it is not under the scope of protection of that patent. So no absolute protection for the isolated gene. The European Patent Office, the other institution from which you can get a national patent in Germany, having the same effect in Germany in theory as a German patent, understood the Biodirective differently, because according to EPC, because they took the Biodirective word by word nearly into the European Patent Convention, allows patents where there is not such a restriction in the claim. Rather, it is only necessary to describe the purpose in the patent somewhere. Then the question is, first of all, of course, What does this article of the Biodirective actually mean? And identically in EPC, purpose has to be described and explained in the patent specification. Does it mean that other purposes can also be thinkable of, can also be thought of, and still the patent claim covers this gene sequence in an absolute manner, also for all purposes, different from what the German legislator meant. The German courts have seen only two possibilities to solve now the problem which otherwise would arise in Germany when exclusivity rights, right to exclude others, is derived from gene sequence patents, maybe for the same invention, one patent granted by the German Patent and Trademark Office, one granted by the European Patent Office, in which the difference in the claims would be that the German one, prescribes the purpose of the gene, the function in the claim. It is for the purpose of doing this and this. And the EPC patent does not prescribe this in the claim. So from a first view, you would think, well, then the scope of protection of an EPC patent covering Germany is wider than of a national patent. Difficult to understand because according to law and theory and case law, both kinds of patents shall have in the member countries of the European Patent Convention the same effect. The German courts then saw only two possibilities to solve this problem. First, they explained already before any early decision was made that they would feel obliged by the explicit understanding of the Biodirective by the German legislator, the parliament, the sovereign in Germany, that indeed the scope of protection of such patents must be restricted in its final effect to gene sequences used for certain purposes. As the German national patent claim prescribes anyway, and as the EPC patent must be, according to the German Federal Court of Justice, interpreted in the same manner. How can that goal be achieved? There are two possibilities. Either when looking at EPC patents in Germany, you understand them in the same manner as if they would be German national patents. This is a way they actually have chosen. That means it is now standing case law. You can read this in all comments on European law, on German patent enforcement case law, that also the scope of protection of an EPC patent covering Germany does not protect an isolated gene in an absolute manner, but only for the purpose which is described in the specification. It does not matter whether this is in the claim, as it must be in Germany, otherwise the patent would not be grantable and would be invalidated later on because of contradicting German law. And in order to achieve equal effects out of the two patents, the EPC patent is understood in exactly the same manner. That was the solution they have chosen and they are following. The second solution they have discussed a long time was the following, namely, simply to think of an easier way to grant compulsory licenses under Biodirective patents. And in this regard, it might be interesting, I don't know whether I have this in the slides, we must think of Article 24.2 of the German Patent Act, which describes a specific form of getting compulsory licenses in Germany. We have the general provision in Article 24.1 of German law,